Yes, Mr. Heston.
My Lord, I appear on behalf of the appellant mother.
Yes.
With me is Miss Khan, who was present and conducted the hearing before Mr. Justice Newton, but had
Yes.
no prior involvement in the matter. The mother, as the court knows, lives at an address which is not disclosed, and if I simply say is in the southwest, is not able to be here today. The respondent is represented by Ms. Renton, Mr. Mani Singh Bassi and Ms. Nadia Campbell-Brunton. They've been instructed on a pro bono basis through advocate, and as I understand it, the father sits at the rear of the court on that side.
Yes.
My Lord, so far as these proceedings are concerned, this is an appeal against the decision of Mr. Justice Newton handed down on the 17th of March of this year, which in turn was the father's appeal against the decision of His Honour Judge McPhee on the 23rd of November of last year, where he refused to recuse himself. Would it assist the court if I sketched out some of the background proceedings in relation to this?
Yes, by all means. You can take it that we've obviously read both Mr. Justice Newton's judgment and Judge McPhee's judgment and the skeleton arguments.
Well, Lord,
and we have looked at the various transcripts of the hearing in front of Judge McPhee.
Indeed. My Lord, can I pick it up, perhaps conveniently, from the chronology, which is extensive, but is the one which appears in the Lord's bundle at page 74.
Page
74.
70.
74.
Yeah.
And my Lord, that sets out the date when the parties met. They married in June of 2019, but separated on the 9th of October 2020, so a short relationship during which the child with which the court is concerned, Joseph, was born on the 2nd of September 2019. He is 3.5 years old. The proceedings started as long ago as the 14th of October 2020, when the father issued proceedings for a child arrangements order. I'm going to spend little time dealing with the intermediate hearing.
Mr. Armstrong, I'm reminded that we're being live streamed, so please don't mention any names.
Indeed. Lord, so far as these proceedings are concerned, perhaps if I pass over some of the intermediate hearings, simply to note that there was a hearing before Judge White on the 2nd of July. I say that is an order which does not appear in the Lord's bundle, but my Lord should have a very short bundle of additional orders, and that is the second and third page of that. It is, if I may say, procedural in terms, and I don't think a great deal turns on it, other than that directions were given for mother to set out a statement by the 13th of July 2021. My Lord will see that at item 4 on page 4.
Yes.
My Lord, there then followed the hearing on the 27th of July, which is at 281. I don't think I need to deal with that, but I think one finally comes...
Sorry to interrupt you, but I have not yet gathered why we're looking at paragraph 4 of this order of the 2nd of July. And paragraph 6 gives the father an opportunity to respond.
Oh yes, I've skipped over that.
I mean, it's a very standard series of directions in a case of this kind.
Indeed.
Yes.
And then one moves from there to the order that it was made on the 27th of July. It's 281 in the bundle. that extends the time for CAFCAS to make its report. A further order on the 30th of July, again extending time and making directions in relation to the listing of the case. And then perhaps importantly for the series of events which the court is considering, the court has in the bundle at 284 the order of District Judge Moses, again a directions order. I think the court has in the bundle the unsealed version, but the sealed version is in the supplemental bundle at page 6. But I don't think anything turns on that order other than the fact that it is in a different format. But can I perhaps pick up from that order, again, fairly standard directions in relation to this matter, the allocation to a circuit judge level, child arrangements in paragraph 2, directions in relation to the progression of contact by the parties setting out their proposals in paragraph 3, fact-finding evidence, the mother to file and serve an updated Scott schedule and statement no later than 7 weeks prior to the fact-finding, father to serve his responses, mother to serve her responses to the father's updated schedule, composite schedule to be provided. Again, standard direction there, disclosure of records, and then if I may move to paragraph 12, both parties to file and serve no later than 14 days after judgment of the fact-finding hearing, updating statements, and section 7 report. And so that, in essence, is the background to the orders that were made and the events in 2021 which led to a fact-finding hearing in June of 2022. But before I deal with that, it is in my submission relevant to look at the order which the court has in its bundle at page 300, which is in fact an amended order was issued by the court, which is in the supplemental bundle at pages 12 and 13, and that is the order of the 13th of January. Now, the 13th of January is going to be an important hearing for the court. That order provides, again, for a Teams hearing, and then orders for the parties to serve updated interim contact statements by the 20th of January. There was redacted disclosures previously ordered shall be provided by the 21st of January. In the event that the mother claims privilege for any document, she shall identify that document and explain why she claims privilege. This to be filed and served by the same time for His Honour Judge McPhee to determine whether those documents are privileged. Outstanding police disclosures to be served by the 27th of January. Police disclosure to be served by mother on the 3rd of February. An updated statement in paragraph 5 and 6. A timetable for mother by the 16th of February, father by the 9th of March, and consolidated Scott schedule with a statement in response to any allegations from the father by the 16th of March. And then the matter was then listed for a fact-finding hearing on the 23rd of March. Lord, that fact-finding hearing didn't take place, and again I'm going to come back to the transcripts of those hearings later on. The child was ill, and the matter was then adjourned. So if I then invite the court to look at page 302, which is the order in relation to that hearing. Again, after the formal parts at 303, the mother was not in attendance, but was represented remotely by her counsel and solicitors. She attended remotely on the second day, assisted by a Portuguese interpreter. Discussions in relation to the finance of the proceedings The court will note that the bundle at that stage was between 700 and 1400 pages, therefore attracted a higher payment. I simply mention that because of the size of the bundle and the issues in relation to case management. No change to the interim child arrangements which were in place at that time. Mother to provide an update as to the child's health. Court reviewed the email withheld from the father contained at Q13 of the index to the court bundle. The court determined it reflects a safety and security concern and does not bear any further than that, but the court will keep that matter under review. The court reminded the parties the fact-finding hearing cannot be extended to deal with every allegation pled, and the parties should adopt a forensic approach. And importantly, so far as these proceedings are concerned, permission was given to the father to file a further Scotch schedule and witness statement, revising and condensing the allegations in his existing statement by the 31st of March. Again, I will take the court back to the transcript in relation to that hearing and the important parts which bear upon that. The outstanding police disclosure costs were to be borne by the mother, and then there was a direction for a further hearing to take place on the 6th of June, and special measures. My Lord, the hearing took place on the 6th of June. The father was at that hearing represented by direct access counsel, Miss El-Sobki. The mother was also represented. The court dealt with the fact-finding hearing, and I think I simply note from page 309 at the top, item C, the bundle was in excess of 1,400 pages, and the court, at paragraph 7, the court did not deliver judgment during this hearing, but the judgment is appended to the order and considered to be handed down, and then further directions were given. As to the welfare stage of these proceedings, including directions for a further hearing on the 9th of September, after the Kafkas report. My Lord, the judgment, I think the court will have had an opportunity to read it, is at page 312, and that deals with the allegations of fact. My Lord, I summarise those to say that the court made a number of serious adverse findings of fact in relation to coercive controlling behaviour and sexual assault against the father. The matter then came back before His Honour Judge McPhee on the 9th of September, and at that hearing the mother filed a position statement, which is at page 391.
This is the 9th of September, you said?
9th of September. And I draw the court's attention to that because it is material. The mother's counsel at that stage indicated that there were some factual matters which were incorrect in the judgment, and at item H made it clear the basis upon which a particular fact which had been found by the judge had been incorrectly recorded by the judge. I don't intend to read that out,
no.
But, my Lord, it is there. The reason for me going to that is, of course, the learned judge's judgment contains a number of adverse findings against the father, but my Lord will see that when one looks at the judgment, what the court has in paragraph 72 on 337, the court can see that the judge has edited the findings to reflect the point which is made in that. I think the rest of the corrections can be described as editorial corrections, and I don't think anything turns upon those. The other matter which the court should be aware of is that the father then, having received the judgment, I think on the 14th of June, appealed against that judgment, and the notice of appeal is dated the 5th of July. For reference, it's at page 343. It contains grounds of appeal, which my lord will see at page 354.
Yes.
There are 7 grounds. I'm going to summarise those by saying that those matters represented a challenge to the facts which were found by the learned judge, effectively saying that the learned judge was incorrect. He supported that appeal by a skeleton argument which we see at page 356, and I identify the grounds which are set out there, but under ground 1, and it is material to later matters, is that in paragraph 19 he makes reference to disclosure. I make this reference because Mr. Justice Newton makes reference to the disclosure, but at paragraph 19 he contends on the 4th of March the mother solicitor withheld court-ordered disclosure from me. At the adjourned hearing on the 24th of March, counsel for myself challenged the other party about the disclosure they withheld from me. The judge reviewed the evidence, stating clearly it was not legally privileged, neither did it pose any risk to the mother. The judge stated he does not see any relevance of this disclosure, and he, to me, and will keep hold of it. The judge was challenged by my counsel, but stayed firm in his position. The mother had been in possession of this for some time. So the father is raising at that point a challenge on the basis of disclosure. I simply say at this stage that paragraph 19 does not accurately reflect the discussion that took place on the 24th of March. And again, when we go back to the transcript in relation to that, I will identify why I say that. I then move to ground 4, which is it's a ground 6, which starts at page 365. It's under the heading, the judge made findings / no findings, which had no basis on the evidence available to him at court. I note that under that, the father stated at paragraph 71 his account of what took place. Again, I'm not intending to read that particular paragraph out, but it's clear that the point about the detail of the sexual assault was raised by the father for the purposes of the appeal. Now, the appeal was considered by Mrs. Justice Arbuthnot on the 22nd of June. The order that the learned judge made is at page 384. I begin with that because the judge considered that permission to appeal should be dismissed, that it was totally without merit, and the father was not entitled to a reconsideration of the permission to appeal application. Mrs. Justice Arbuthnot deals with the judgment and deals with the challenges to it, and comes to the conclusion that it is a series of findings which were well open to the judge on the evidence before him.
Yeah.
And again, for present purposes and because it's material, I direct the court to paragraph 59 of the judgment. And at the foot of the page, one can see the view taken by Mrs. Justice Arbuthnot. Whether the father's penis actually entered the vagina or just was on the edge is neither here nor there. There was much evidence of sexual assault, which the judge found credible. So that is the preface to the hearing before His Honour Judge McPhee on the 9th of September. My Lord, there is a transcript of that. I'm asked to point out that it wasn't in fact before Mr. Justice Newton, so I leave that for a moment, but the orders that were made by His Honour Judge McPhee on the 9th of September are at 399 to 403. And the order is in fairly standard terms, moving past the legal aid recitation. Paragraph 3 and 4, domestic abuse has been raised as an issue which is likely to be relevant. The court is satisfied that the arrangements provide for the safety and well-being. The case management decision, number 5, the court found on the balance of probabilities that it would not be in Joseph's interest to continue to undertake a 6 to 8 hour car journey fortnightly, but noted this was not indicative of any final decision already having been made in these proceedings. And then in relation to item 7, the father invited the court to set aside its findings or to conduct a wholesale review. Both parties raised amendments to the judgment made in the fact-finding hearing. The court agreed to review this judgment and recirculate the amended version in due course.
So Judge McPhee is amending the judgment after the dismissal of the application for permission to appeal. That's the chronology.
Indeed. But if I may backtrack, the point which was being raised by the father in relation, the point which was raised by the mother was one which had been taken by the father in his permission to appeal application and dealt with by Mrs. Justice Arbuthnot in the paragraphs that one has looked at already. So the judgment, I think, is recirculated at some point after that. I'm not entirely sure as to the date when it was received by all parties. The judge, if I move forward, deals with the interim child arrangements, continued arrangements for interim contact, but these were to be in the southwest of England as opposed to travelling to London. I simply say that there is a CAFCAS report in the bundle, and the CAFCAS officer, having reviewed the matter, considered that continuing to have lengthy car journeys fortnightly was not in the child's best interest. But again, if necessary, one can look at the judgment of the transcript of the hearing before His Honour Judge McPhee on the 9th of September. So I pause there to say that so far as the revisions to the judgment are concerned, the court will see that there was an order which was dated the 9th of September, but I think came out after that. But one sees that at page 404, and the learned judge dealt with the amendment to paragraph 72.
Second order, the 9th of September. Second order dated the 9th of September.
Second order dated 9th
Thank
September.
you.
So, I simply say there's been no appeal against that decision, and indeed, if pressed, I would simply say it's already encapsulated within the appeal. So the next hearing, the next matter which concerned the court was the mother's C2 application.
Mr. Armstrong, could we just pause at this point? Just remind us, what was the onward plan for the welfare hearing? Was there a date for
Yes,
a welfare hearing? If I've missed it, I'm sorry.
I think the date that was planned for that welfare hearing was the 6th of January, and if I've just given one
Page
second.
401, paragraph
401,
15.
indeed.
Thank you.
And that provided for the author of the Section 7 report to attend, and I simply revert back to paragraph 5, where the court in its order made a decision on an interim basis in relation to car journeys. But,
and the issues for the January hearing, what were the fundamental issues?
as to the progression of contact.
It was about contact.
Indeed.
Right. At that stage, when this was being listed, international travel had not been formally put on the roster, as it were. But what you're about to tell us shows that it soon did.
Well, there were a whole series of issues that would be dealt with. One of which was Brazilian nationality,
Well, that was raised in the specific application that was made in October.
Indeed.
I've got one question about the procedural history that you've described. One of the complaints made by the father was that the mother was always given longer, or at least sometimes given longer. Could you just situate that at some convenient point in the chronology?
I will do that. The point which was being raised by the father was that the mother was given longer. The date of that hearing was in fact the January hearing.
January 21.
January 22.
22, sorry.
300.
300.
We looked at that in passing, didn't we?
We've looked at that. My plan was to set out
Yes.
the broad canvas of the orders and then to come back to specifics. But in answer to my Lord's question, what happened at that hearing, and I summarise, the father complained about mother being given time. He was then asked in terms, how long do you want to respond? He said 3 weeks. He then said, could I have 4 weeks? And the judge said 3 weeks. He said that's not enough, but the judge then pointed out that we had to maintain, or that the court had to maintain a hearing on the 24th, which both parties were keen to maintain and not lose the date. And he pointed out that so far as disclosure was concerned, that is disclosure from the police, he was going to have that ahead of time, either on the 27th of January 2022, or very shortly after that, when it was formally disclosed by the mother. Actually,
when we're talking about 3 weeks or so, the dates, and I appreciate you'll come back to this, but the date of the hearing is the 13th of January, and the relevant parts are to do with the service of Scott schedule, the response to Scott schedule.
Indeed, if I go
Right,
back to...
so the dates there are onward from the 13th of January. The mother gets to the 16th of February,
Yes,
and the father gets to the 16th of February, plus 3 weeks.
indeed. Which would then take us to the early part of March.
Yes, and the 9th of March is near enough to the hearing to mean that 4 weeks might make things different.
Indeed.
Right, understand.
If I may put it, it's classic case management timetabling, trying to make
Yes,
sure
but the point
that...
I'm making is that the father wasn't given 3 weeks. He was given 3 weeks plus the length of time that the mother had.
Indeed.
I appreciate he was responding, but he knew the nature of the allegations that were being brought.
Indeed. But, my Lord, so that my Lord has the point fully in mind, we know that the hearing didn't take place on the 24th of March. And indeed, it was then scheduled for June. The reason it didn't take place was the child was unfortunately ill, which prevented mother's attendance. But during the course of that hearing, and it will be seen from the transcript, there was discussion by counsel who represented the father, who said that he wanted to tidy up some parts of the evidence.
This is the June hearing.
No, this is in the hearing on the 24th of March.
When it was adjourned,
when the judge was considering directions for the adjournment, the judge,
Father's counsel
asked for an opportunity to tidy matters up and was given, in fact, 7 days to do that. He also, I mentioned this in passing, he said father was raising with him matters that he didn't think were particularly relevant, but there might be other matters which the father did consider to be relevant, or, sorry, let me start again, which the father hadn't considered to be relevant, which he as counsel might consider to be relevant. And the judge said, well, if they're not available by the 7th, they're not available within the 7 days, you may have to make a C2 application in relation to that. But at all events, we have a hearing which takes place over 2 days of evidence on the 6th and 7th of June 2022, where father is represented. And if I make the point, before I go back to the transcripts, if there was indeed continuing complaint about inadequate time to put statements, or inadequate disclosure, or any other procedural matter, it would have been incumbent upon counsel for the father to raise it and for the judge to determine that issue. And of course, so far as we can see, the only matters which are dealt with are the matters which relate to the hearing on the 6th and 7th of June. The judge was due to sit on the 8th, but I think was no doubt preparing his judgment, which was then, I think, circulated on the 14th of June. I simply say that, and this is an overarching point, whatever procedural complaints the father had in relation to the way His Honour Judge McPhee had conducted the case management for that hearing, any complaint should have been made by the father's counsel to the court, determined, and if necessary, would become the subject of an appeal. Those matters which were the subject of the appeal did not include any case management hearing. We've looked at the grounds of appeal. Can I just take the court back to the grounds of appeal for
you've shown us those, Mr. Armstrong.
that hearing. They're short, they're confined to factual matters, and I've identified within the 7 points which are set out on page 354, I think it is.
But the puzzle is that Judge McPhee seems to have thought that these complaints were the subject of the appeal when he came to give his ruling on the recusal application.
Well, I'm going to approach the matter on the basis that His Honour Judge McPhee was entitled to say that any defect in case management which had occurred prior to the final hearing would have been addressed within that fact-finding hearing, 2 days of the parties giving evidence about matters, and therefore it was not necessary for him to revisit those decisions within his judgment. My Lord, page 354 is the...
Well, the question is not whether he was entitled to say it, but whether he was entitled not to say it, which is the problem. Well, it is your submission essentially that he didn't say it because it's obvious that that's what he would have said.
Well, my lord, I'm going to go on in due course to look at the law, but so far as the allegation of not actual but apparent bias is concerned, the court is in the position of a neutral observer who is acquainted with all of the facts. And I'm going to submit to the court the neutral observer for these purposes, looking at the matter in November 2022, will be apprised, as the judge was, as the father was, as all parties were, with the procedural history of the case.
Anyway, you're taking us in a granular way through the, not complaining, through the, what you say are the case management issues which are pertinent to the appeal. And on the question of the father not having sufficient time to respond, or an unfairly abbreviated time, your point is that, well, you made...
Well, there's 2 points. If I may call it, the overarching point is that any complaints are subsumed within the appeal process. But my secondary point to that is, as one examines the transcripts, they are not made out at all. They're perfectly proper case management decisions which do not unfairly bite upon the father. My lord, I'm slightly taken out of my course, but only because we've reached September 2022, and what happens then is mother makes the application for flu vaccination by nasal spray. And that application, the court will see at page 406, in fairly standard terms, and to that application is appended a rider, and one sees the rider at pages 414, 415. Item 1 is the flu vaccination. Item 2 is the registration as Brazilian national and application for Brazilian passport. Item 3 is travel abroad. I can summarise the matter by saying that the learned judge said he wasn't going to deal with either 2 or 3 until the final hearing, which leaves us with the nasal spray, and appended to the application are, if I may say, the information which is provided to parents about the benefits of nasal spray vaccination for children. Again, I don't intend to deal with those, but the matter comes before His Honour Judge McPhee on the 16th of November, and he is asked in relation to that. Let me start again. He makes a direction which is in line with the authorities in relation to the provision by the mother in paragraph 2 of a letter.
Right, what page are you on?
Page 432.
432. Yes.
I mention this because father considers that it's a complaint. The mother is asked to provide the GP evidence that there is no contraindication to the child receiving the nasal flu vaccination. My lord will see that at paragraph 2. I think the rest of the directions relate to that.
So apart from that, there was no direction for either parent to file a statement of evidence on this issue.
On that issue. The mother provided a skeleton argument, which you will see at page 435. And that deals with the issue of flu vaccination. And recites what is proposed. and a summary of the legal principles in relation to that. It also deals with what might have been a contested issue of that. What happened at that hearing is, of course, that the father provided a document. I'm not entirely sure whether it was provided prior to that hearing.
Well, that was my question, Mr. Armstrong. The document at 439. Sorry, I'm leaping ahead. Forgive me if I'm wrong. Was that available to the judge at the hearing, or was it the speaking note
I
which
think
the father used for his submissions and was then given?
So far as I'm aware, it was the speaking note which was provisioned, because when one looks at the transcript of that hearing, it does seem to come as something, if I may say, something where the mother's representative, I think the solicitor acting for, is taken by surprise. I'll come back to that.
So it was a speaking note,
Indeed.
was it, rather than given to the judge before the hearing? That's how I read it.
Certainly, that's how I read the.
Miss Renton's nodding.
The transcript shows the father reading it.
Yeah, but that would.
And I think the transcript also shows the element of surprise, if I may put it, by the representative on behalf of the father.
Forgive me, Mr. Armstrong, had any indication been given to the judge, so far as you're aware, before the father started these remarks, that he was proposing to apply to the judge to recuse himself?
Not as far as I'm aware, but I'm going to take thought to the transcripts again in relation to that. And just so that the court has the history, the judge adjourned the matter for a week. That order is 444.
Forgive me again for interrupting you, Mr. Armstrong, but was the speaking note supplied to the judge between the two hearings, the 16th and the 23rd, or not?
I don't think so, and the reason I say that is because you will see from the transcript when we come to it that the learned judge said, well, you spoke very fast indeed, and what I've done is to go back to the tape and listen to it again. Of course, that would have been somewhat unnecessary if there had been a note which he had been provided with.
Good point, Mr. Armstrong. But I think,
I'm going to pause there and say that on the 23rd, the different representation for the mother was present, and the judge dealt with the applications in the order of recusal, and then moved straight away to deal with the issue of the nasal spray. Now, whilst father has a complaint about that, and the court will see that Mr. Justice Newton raised that as being an issue, but on behalf of the mother, I would say that's a perfectly proper way of dealing with it, and indeed the court will look at one of the cases where the recusal application was dismissed. The court continued with the hearing of the application, and the reasons were given afterwards, and the court considered that was entirely appropriate, and in fact an appropriate case management method of dealing with the case. And I'll come back to that shortly. So the judge refused to recuse himself. He ruled in favour of the nasal spray application. Father did not appeal the nasal spray application, and indeed did not ask for a stay of the proceedings. I pause for a moment to say there that in the course of Mr. Justice Newton's judgment, there seems to be some reference to the fact that it is suggested that the father should have been given some warning or some additional information. I pause there simply to say that the father had made a comprehensive appeal in July. He would have had the N161, which he completed for those purposes, and in the course of the N161 for that hearing, for that appeal, he in fact ticked the box which deals with stay. Can I take my lord back to 343 for a moment, which is the notice of appeal. This is completed by the father on the 5th of July, and if one turns to box 10, which is on page 350,
Yes.
I apply for a stay to stop further steps being taken. My lord, the position of litigants in person is no better than other litigants, as the court has ruled on many occasions, but it would simply be incorrect to say that father did not know the steps for an appeal or to apply for a stay. My lord, there then follows the appeal before Mr. Justice Newton. The grounds of appeals. The appellant's notice is dated the 14th of December, so some weeks later.
It's 466, the grounds of appeal. Right?
Indeed, there are grounds of appeal which the court has, and I think they're 466. Mine seems to have moved out of the bundle, but there were 5 grounds of appeal which were advanced in relation to that. The judge fell into serious error and unfairness in the finding of rape which had no basis on the evidence. Similar errors have been raised by him, but he's repeatedly refused to review his judgment of the 8th of June. The appearance of bias is further compounded by the judge's inability to offer any explanation as to how these errors occurred. Item 2, the judge created the appearance of bias by conducting hearings in contravention of Family Procedure Rules 1.1. That's the overriding objective in Article 6 of the Human Rights Act. The judge afforded the other parties significant opportunities that were not afforded to me. The judge restricted and prohibited me from filing evidence and statements at numerous hearings, but allowed the other party to file unlimited evidence without restriction. This did not place us on an equal footing. The judge created the appearance of bias when he failed to acknowledge the serious allegations that present a risk of harm. I pass over that because Mr. Justice Newton contended that that did not raise an issue. The judge made comments that created the appearance of bias and unfairness. The manner in which the judge disposed of my application further raises the appearance of bias. The judge failed adequately to explain his reasons for refusing to recuse himself. Lord, the judgment of Mr. Justice Newton, the court will have looked at already. That's page 243 to 257. I make the criticism of that judgment in short terms that it does not deal properly with the Porter and McGill position in relation to issues of bias, because the court should, in my submission, carry out an appropriate investigation of the issues to determine whether or not there is any substance in them. He made a number of points, or the father made a number of points for the purposes of that hearing, but in my submission it forms that classic cherry-picking, island-hopping approach to allegations, but without there being any substance to the matters which are being raised.
But was Mr. Justice Newton taken through the procedural chronology in the way that you have taken us through it.
He certainly had the bundle.
Well, I know, but the mother was represented.
Indeed.
If there had been no substance in any of the father's criticisms of the case management decisions, one might have expected, since Judge McPhee didn't go through them, counsel for the mother to explain to Mr. Justice Newton that there was nothing in these complaints.
Well,
I couldn't see that in the transcript.
well, my lord, perhaps it's convenient to deal with the transcripts in this way. Miss Khan had filed a skeleton argument for the purposes of that hearing. It is again a
Is that at 488?
488. Yes, indeed. And that set out, again, the history of this. It deals with the fact-finding judgment of Mrs. Justice Arbuthnot. I'm looking at paragraph 9C, where the judge did not offer the respondent greater latitude and or restricted the appellant unfairly, thereby causing the appearance of bias. The significant overlap between those decisions and the grounds of appeal are addressed in terms.
That document was, how I got this right, Mr. Armstrong. Ms. Carr's document was filed in response to the father's skeleton argument,
Indeed.
which I think, and correct me if I'm wrong, is the one at 468.
Indeed.
I'm sorry, I'm just so you can orient us.
The,
I'm looking at a document at page 447, which on the face of it is the position statement for a hearing on the 23rd of November, and which goes into paragraph 7, grounds for recusal, and there is A to N at paragraph 7 on page 448,
indeed.
in which everything is pulled together.
Set out, and indeed the position in relation to the steps.
So this is the document prepared by previous counsel for the mother, correct?
Yes, indeed.
For the hearing, for the adjourned hearing before Judge McPhee on the 23rd,
Indeed.
to which the judge refers in the transcript.
Indeed.
So paragraph 7 seems to represent one point of reference, quite a rich one, for all the sorts of issues that had been gathered in the father's complaint. I'm just trying to see whether this is a misunderstanding. That's so.
I think the point is made as mother's response in 8, 9 and 10 to the propositions which are advanced, but perhaps it
I'm not
may be...
concerned at the moment with the mother's case, but the
Indeed.
extent to which the judge had the document, from which one can see whether he would or would not have been aware of in some convenient way, of the nature of the complaints being made by the father, in addition to the father's speaking note and oral submissions. And there it is.
Well, the father, for his purposes, had filed a skeleton argument for the purposes of the appeal to Mr. Justice Newton. I think that's 468.
Yes, I'm
The
sorry,
Lord is
we're
going.
at cross purposes.
Sorry.
At the moment, I'm trying to be clear about what Judge McPhee had when he came to give his his decision, not what Judge Newton did.
I'm terribly sorry. I was.
Yeah, I mean, what we've established is that the father had a document, but he may not have handed it over. He read it.
Indeed.
The judge then listened back to what the father had read, but the judge also had the advantage of having at paragraph 7, I'm not going into whether it's a fair summary, but a professional summary of the points that the mother's representatives considered the father to be raising.
Indeed. I move on to Mr. Justice Newton's judgment, and in answer to the question that was put to me, the just find my place again. The transcript of the hearing before Mr. Justice Newton is at 168. And Mr. Mantawi begins speaking.
We don't mention names, please, Mr. Armstrong.
So the father begins speaking.
Yeah.
One will see that, and I think the remarks are fairly introductory. Page 174. The judge is dealing with the issue of the appeal, and one of the grounds of the mother's appeal for present purposes at page 18C is the judge at the outset stated that the respondent's grounds in relation to the error in the finding of rape and substitution could not be considered. I simply say that page 174 is a clear statement that the judge is dealing with the matter on the basis of the judgment of Justice Arbuthnot still standing. What one then sees after that is Mr. Justice Newton trying to pick out particular items from the father's case. One sees this at page 177 at A. To D. And this is perhaps some evidence of how the hearing took place. At just above C, there's an aspect I'm anxious about, which you raised, but not very forcibly, when you asked the judge on 16th of December to ask how he's going to deal with it, because you suddenly launch into, without any warning, your recusal application. So Mother's Advocate, I think, dealt with it as well as she could, with no prior warning as to what would happen. You launched into it. It's quite a well-argued, comprehensive application, and quite reasonably asked how to deal with it. Is he going to adjourn? Well, how's it going to happen if you adjourn? Are you going to deal with it? So these are aspects I think you should think about. Page 177G, father says he's not going to raise the rape appeal. 178, bottom H, the father is dealing with, I raised a number of issues dating back to January 13th at the hearing where the mother was given an extension. He says, I was unaware of judicial fairness and bias. He then goes on to the disclosure issues. And he complains about the extension of time. I'm going to say that those paragraphs are not a fair reflection of what took place. He then harks back to the order of the 25th of October, and then he jumps forward at page 180 at E, trying not to jump forward too much, but if you look at the judgment, you can see absolutely no mention about disclosure. We say that that is a further attempt to rerun an unsuccessful appeal in relation to those matters. He goes on to say there were certain issues were dealt with in relation to relocation opposed as to what disclosure determined. I say in particular he included in contradiction to the evidence or the facts without any explanation why the facts were dismissed. I have no reason why the evidence was not considered. Again, we say that that's not a fair reflection of what took place. Going back to my point from the 30th of January where the judge was happy to proceed without disclosure, there's no reference to that disclosure in his judgment. Again, that's an attack on the fact-finding hearing.
To this point, apart from the rape, which has been disavowed, we have 2 points to read. She gets more time than me, and there are documents that have not been disclosed to me and are then not referred to.
Indeed.
Right. Are there any other, to this point in the transcript, any other sorts of complaint?
I don't read those grounds as generating that. So far as the matters which perhaps are important for the court in relation to this, we have Mr. Mantawi saying at page 191,
The father.
sorry, I apologise very much. We have the father saying at 191, item C, I will move on to the hearing on the 24th of March. I've only just received the transcripts for that hearing. I believe they're about 23 pages long. Paragraph 33 of my skeleton argument, paragraph 34, deals with that. I pause there for a moment. Whilst Mr. Mantawi had...
Mr. Armstrong, the father.
I sincerely apologise.
Can we just break into this and go back a stage? I'm trying to gather what were all the things that Mr. Justice Newton was told was wrong about Judge McPhee's treatment. Reading at the top of page 181, then I move on.
Yep.
The mother's non-attendance at the fact-finding hearing. And then there's a whole page in which Mr. Justice Newton says, how does that assist you? Because the fact-finding hearing didn't take place because the child was accepted to be ill. So that was a complaint that was designed to show that Judge McPhee had an appearance of bias. Yes?
Indeed.
Right. Can you help us by, instead of jumping forward in the transcript, just identify whether there are any other matters that were being raised to show that the judge was apparently biased?
The disclosure of documents is something that
we've had that.
He raised. My Lord, so far as the matters before the judgment, the answer is no. I don't think there is anything else.
So it's the fact that the mother had had more time than the father to prepare, and the fact that the arguments about non-disclosure. Are those the points that were raised?
Indeed.
Orally.
Orally.
And the fact that the mother had been ordered to attend the hearing and didn't.
Yeah.
He raises points as to the hearing in front of in front of His Honour Judge McPhee in relation to the revision of the judgment. He raises issues as to what he describes as directing the mother's legal representative on the 16th of November to deal with particular issues and to, in effect, he regards that as being evidence of prejudgment.
Where's the reference?
I find it in the judgment of Mr. Justice Newton, paragraph 41, page 253, it will take me a little while to find that particular point in the...
There seems to be a complaint on page 188 about filing of evidence between F and H.
I think that is in relation to the nasal vaccination issue.
Right.
So that's another complaint.
Indeed. Lord, I think those are the matters which he substantially raised in that he complains about asking for a stay. One sees that at 203C. And he raises the point about dealing with the issues of recusal and nasal vaccination at 202C and top of 203. I hope, without being unfair to the father, I've identified those particular matters. So far as the transcripts before Mr. Justice Newton, I'll be corrected if I'm wrong, but I'm told that the transcript of the hearing on the 13th of January was before the court. The transcript of the 24th of March was not before the court during the course of the hearing, although the father referred to it in the passage that I was looking at just a moment ago, where he says he has just received it. One sees that at 191C, but of course he then sends that to Mr. Justice Newton by email after the court had finished sitting. One sees that at page 525.
I'm sorry, what was the page number again?
525 is where he sends it to the court. He doesn't make any submissions in relation to it, in fairness to him, other than identifying two particular points. The mother's representatives objected to that. The judge did not invite any further submissions by either party in relation to that, but it seems to be the case that he referred to that in the course of his judgment, where he says that he's seen particular items. So far as the hearing before Mr. Justice Newton and the judgment, having set out
243.
243, it starts. Having set out background, he refers to background matters in 1 to 5. He then refers to the change in the judgment. He acknowledges that the father has not issued an application to appeal the order. He refers to the order on the 26th of October providing for the filing of the evidence. He records the transcript, and he, in effect, records repeats those matters which are referred to within the transcript. I just point out in passing at 247, there's a reference to the 8th of June. You allowed counsel for the mother to add conditions to contact that they were not discussed, agreed or ordered by yourself. I think that must be a wrong reference because the only change to the contact did not take place on the 8th of June but on the 9th of September, and the change to contact was the removal of the child being transported by car for a very lengthy car journey. Mr. Justice Newton summarises those particular points in paragraph 14. An inconsistent approach in relation to the filing of evidence. The judge had withheld pertinent documents, and the amendment to the judge's findings.
That's a summary of the point. That's Mr. Justice Newton's summary
Of the
points made by the father to Judge McPhee. Is that right?
Indeed. He then goes on to say that the finding that reached by the judge was as a matter of law wrong. He submits, notwithstanding submissions made on behalf of the respondent, that it only occupies 9 lines reiterating his position in relation to the findings. And Mr. Justice Newton continues, I'm not assisted in the least by the implication of second order, putting Mac's right did not come into being until some time later. Concerned about the criticisms made by the father, particularly through the prism, of whether there was disproportionate allowance given to the mother. I simply say that on examination of the fact, there was no disproportionate advantage to the mother.
Well, this appears to be a reference to paragraph 12. Is it not on page 245?
Indeed.
Well, I mean, the fact of the matter is, in relation to routine vaccinations, the law is perfectly clear. They happen unless there is some medical counterindication.
Indeed. When the court looks at
detracting from the fact it's a welfare decision, that's the practical state of the law on those matters at the moment. And so one might have thought that it would have been wrong for the judge to have allowed for statements from either party on an issue of that relative triviality.
Indeed, as you will see from the transcript in relation to that, the father accepted that there was no contraindication to it. He put forward 2 statistical points as to benefit or not, but did not seem to want to advance any further point, though he was given an opportunity to.
In a sense, it wasn't. I mean, the judge knew that for her reasons, the mother would like the treatment to take place, and the father, for his reasons, would not like it to take place, at least not now. But he wasn't about to embark upon a state trial of that issue.
It's a short matter which requires determination one way or another. The reasons and the advantages of it are clearly set out within the mother's application notice, which includes all the material from NHS England in relation to it, not contraindicated. So it is.
But I mean, just in trying to understand what the judge means at paragraph 50, there appears maybe to be some implication, not for some reason from the father, or even the filing of any response, to be a suggestion that there was something unusual about that. But actually there was no evidence from the mother either.
Well, if you read the transcripts in relation to the father, seems to be somewhat, if I may call it, neutral in relation to the issue. His only point was what is the benefit for it, as opposed to taking matters any further than that. Can I perhaps address that? And it may be sensible simply to look at the transcripts in relation to that part of the hearing before Mr. Justice McPhee, which you see at page 137. that is the hearing on the 16th of November. Miss Roberts is the representative for the mother, and the father is acting in person.
Yeah.
Miss Roberts had provided a note for the court. It's all referred to at page 139, and the judge deals with that, and then he turns to the father, and we see the beginning of that discussion at page 141 at line 14, where in response to the judge's comments, you've seen the additional information, you have a contra case to put forward. The response is, Your Honour, we'd just like a couple of points clarified. So on my understanding, it's just to determine whether whether the child received a flu vaccination or whether the mother has permission. I agree with that. How is that decided? I know you ultimately have the final decision. What will you base your decision on? Judge responds on the submissions made to me by Ms. Roberts, who's made her submissions, reading of the case law and clearly what you have to say about it. And then he refers to the correspondence, line 25. The short point is that the father had prior warning of the application. He complains about the mother's application in relation to the nationality. And then his position is set out at page 142.
Yeah.
And I don't read from that. There's lots of complaints about other matters, but I do not read in relation to that a positive case being put forward. And he continues at line 18, the mother does not need my consent for medical treatment as she's already proven she made life-changing unilateral decision regarding the child, including relocating 300 miles away and so on. And then at line 29, he says, I believe it's public knowledge that GP would not offer medical treatment if there are reasons that prevented you from receiving. Therefore, there was only ever going to be one possible answer the GP could have given, which leaves me confused as to why other questions were not asked. For example, does Joseph have any medical conditions which would put him at risk if he did not have the vaccine? Your directions afforded the mother the advantage to enter expert evidence to support her case, to add to the further advantage she's filed. In comparison, you're not directing me to file any evidence or statements. I cannot feel my presence here today is futile. I've done my best to understand the family procedures. And then he goes on from there into the allegations of bias. I simply pass over those for a moment because he reads out from his note. And then at page 146, line 11, the mother's representative says, Your Honour, there's been no prior warning or notice the father was going to be making of this particular application today. Your Honour has already made it clear he wasn't going to consider other practical matters. Are you asking for more time? There's a short adjournment. Thank you for the time to take brief instructions at the bottom of 146. Not agreeing it and pointing out the advantages of judicial continuity, as we can see over the page from line 5, stating the point that the mother does not agree that Your Honour should recuse yourself. It's not unusual for a party against whom findings are made to feel dissatisfied with the outcome were based upon evidence and so on, so rejecting this. A reference to the draft of the order not having been provided. Ms. Roberts says, I haven't seen another order from the 9th of September. Maybe it hasn't come through to us. Should have done it. Maybe the court officer was confused because 2 orders came out. one that dealt with my own to deal with paragraph 72, so I cannot conclude the hearing until you've seen that. The other issue is, have you seen the reasons Mrs. Justice Arbuthnot refusing permission? Again, I've taken the case over recently. I'll look to see if we have it. She says she has it on the system. And then at page 148, there is perhaps an important reference there to the point that the father was making about evidence being removed from the bundle. Ms. Roberts saying we have responsibility for preparing the bundle, being the legal and only representative. My understanding generally is that evidence which was specifically for the fact-finding hearing, on the basis the judgment effectively replaces the evidence which become the basis on which future decisions are made. Part of the reasoning is to ensure the bundle remains within the limits which are dictated by the family procedure rules, including all the evidence would take it over the limit. If the court determines the evidence should remain for the final bundle, we can do it. I simply say that the evidence for the fact-finding hearing was about 1,400 pages. What was being edited down was a standard bundle, less than 300 odd pages, in accordance with the practice directions. And then Judge McPhee gives the mother's representative an opportunity to take instructions. I think it's only, this is 149 line 4, I think it's only right that you be in a proper position to take instructions, there being no prior notice. So I think I cannot determine, unfortunately, either application to a conclusion saying you've had an opportunity of taking instructions with an interpreter. Otherwise, we risk matters should be properly submitted being lost through that process. So it does seem to me that, contrary to what I've said earlier, I did not want another hearing. I'm going to have to pick a further hearing to allow you to finalise your instructions, give me a clear response. I mean, I do think one of the clear responses that I would give in respect of the matter is that a High Court judge looked at the fact-finding hearing, gave a clear judgment to the appeal, having considered a number of matters, and those ought to be outlined to me properly. I raise that passage simply because the father refers to that as a predetermination, and if one looks at the judgment of Mr. Justice Newton in relation to the decision, he does appear...
Are you leaving this transcript for the moment?
He does appear, I'm cross-referencing to paragraph 41 at page 243, that leaves the remarks made to counsel on the 16th of November, foreshadowing the judgments. I simply refer back to the passage and say that the learned judge asking for assistance on a particular point is nothing unusual or which would indicate or give the appearance of bias at all, although the learned judge seems to consider that that is part of the picture. And then the matter is adjourned. I think it's important that one looks at the final pages of this hearing on the 16th of November, where the judge outlines what's going to happen in response to a question from the father. I will hear updated submissions on behalf of Ms. Roberts. I'll allow you an opportunity of responding to those submissions. Then I'll provide you a decision on my recusal, and I do recuse myself. The issue of the flu vaccination will have to go before another judge. If I do not, I will give you my decision in respect of that. Is there any evidence to be filed? No, by either party. The judge says, I do not need any evidence. You, in your submission in respect to flu vaccination, gave me two figures, efficacy rate and the 50% take-up rate. If you want to file evidence over those figures rather than just saying them, I give you leave.
That's what the father mentioned to Mr. Justice Newton, I think, about the two figures, isn't it?
Yes, indeed. And that's picking up from what the father had put forward in the early part of the judgment, 142 line 4, as being those two figures which seem to be the basis of his objection. He then says, should it not be more appropriate just to focus on the application of recusal? You've asked me to plan for that. No, for the recusal, you've asked me to plan. You might have. And Judge McPhee puts it very clearly. There are two issues now. I'm going to deal with the recusal first. If I recuse myself, I will not deal with the vaccination hearing. I've said that. If I do not recuse myself, I will go on to give a decision in respect to the vaccination, but I allow you the opportunity of filing evidence about the figures you've quoted. And then father says, okay, understood. And then there's a reference to asking what the status of Miss Roberts is. I don't think that's material. And the matter resumed on the 23rd of November. With the judge reciting at page 154 the position that had been reached. And he asks at the bottom, so Ms. Swanton, do you agree that course of action, that summary? And she says yes. And then he turns to the father, do you agree that summary? And he says yes at line 6. So,
and by that point, he'd had what he describes as a very careful position statement from the mother.
Yes, indeed.
Which is the document we saw a little earlier.
Yes, indeed.
With paragraph 7 summarising the father's points. Is that right?
Yes, indeed. And then she's asked whether she wants to add anything. She says, I don't think so. And then he turns to the father. Anything you needed to add? Respond to the submission. And then he makes the application for refusal.
Yeah.
You don't need to repeat that. And then a reference to re K, a reference to re C. Did find the fair-minded observer, so that those are, if I may put it, legal points in relation to that as to the approach. And he says at page 156, line 21, I heard you at length on the last occasion. I made a note, and what I've done, just to let you know, is I listened back to the tape recording of what you said to me. Because, of course, it came thick and fast, so I've listened back and made notes of that. I do not need that repeating. A couple more points. And then a reference to the judgment.
That's the amended judgment on
the amended judgment at page, paragraph, let's start again. 156, line 29 is a reference back to the judgment. And his position is you went on to make all the amendments, typographical and then the substantive amendment, despite serious errors. No explanation as to how you could make such a grave error. More concerningly, the mother gave yet another variation of this allegation to her position statement, and that's a reference to that. And then with the reduction of interim contact, and that concludes the submissions at that stage. We then have the recusal judgment, which Lords have already seen. The recusal judgment at 161. Where the judge is applying the Porter and McGill test. He puts no gloss on it. And then he continues, the reality is that all of those matters were before Mrs. Justice Arbuthnot on the 22nd of August, when she dealt with the appeal that father sought to make against the decision I've made in respect to the fact-finding hearing. The learned judge found that the appeal was totally without merit, said that there would be no further oral reconsideration of the application for permission to appeal. The vast bulk of the allegations that father makes were considered by the learned judge in respect of those appeal, those case management decisions, fact findings, and addition in respect of the allegation that I'd found in paragraph 72 whilst on honeymoon.
Is that correct, though? They could have been before Mrs. Justice Arbuthnot, but were they? And did she consider them?
Well, the answer to that would require me just to go back to the judgment to the material before.
Well, you've shown us the grounds of appeal.
The grounds of appeal didn't raise it.
What Mrs. Justice Arbuthnot said.
There's 2 points. One is, on the procedural matters, there was no appeal in relation to any of the case management decisions.
That's a different point, though, isn't it?
There's 2 points, I think. One then moves to look at the disclosure point, which is referred to in the course of the skeleton argument. And then there is the, if I call it the revisited allegation, where the learned judge revises his judgment. That is foreshadowed within the judgment of Mrs. Justice Arbuthnot in the passages which I refer to. Can I just take you back so that I can make the point so much more clearly? The father's skeleton argument in relation to that is at page 356.
Yes.
And he noted at the beginning that he was represented for the fact-finding hearing. We have the disclosure issue in paragraph 19. We have the issue in relation to the precise incident involving the father within the father's own skeleton argument at paragraph 71.
So paragraph 19, paragraph 71.
Yes,
Was there another paragraph you mentioned in between? Or did you just go straight from 19 to 71?
Sorry, I was just trying to address my Lord's point in relation to the revision of the judgment, because the paragraph 71 is the one where the revision to the judgment, and Mrs. Justice Arbuthnot deals with that in her judgment very clearly within paragraph 59. So the point is clearly that issue raised by father within his own grounds of appeal is before Mrs. Justice Arbuthnot.
This is before the judge revised his judgment, though, isn't it?
Yes, indeed. Father's raising a point, saying that the judge has got it wrong in relation to the precise terms as to in which the assault took place. It may be that he was raising that point for his own purpose, to say that it wasn't an allegation of rape; it was supposed to be an allegation of assault in a different way. But he's raising that issue.
Mrs. Justice Arbuthnot says that although there is or may be an error, it's not material.
Indeed.
Going back to where you were, which was in the short judgment of Judge McPhee on page 162.
Sorry, I was just getting a...
162. At paragraph 3, he says at the last sentence, in describing the bias issues raised, a number of issues. Some of those were of case management issues. Some related to the facts. Or the fact, he may mean of a single mistake. But he is there dealing, he's alluding there to case management issues of the sort that we've been picking our way through. And he then refers to, in paragraph 4, where you've already taken us, to matters that were considered by Mrs. Justice Arbuthnot in respect of the appeal. Now, apart from the disclosure issue, which was specifically raised, those case management decisions were not specifically alluded to by Mrs. Justice Arbuthnot because they hadn't been raised as a ground of appeal.
Indeed.
And so effectively what the judge appears to be saying is that they're caught up, you might say, in the dismissal of the appeal as a whole.
I use the word subsumed within the...
Did you use that word? I'm sorry. Right. But it's perfectly apparent, it would seem to me, from paragraphs 3 and 4, that although the judge may not and might have done better to have listed, as we see in paragraph 7 of the skeleton argument which was given to him for this purpose, all the father's miscellaneous observations about his conduct of the proceedings, they were case management issues, viewed generically, and the judge was aware that he was being taken to task for them.
Indeed. And if I go back to what I submitted earlier, which is the Porter and McGill observer would be as aware as father was, and the court was, mother through her representatives, of the decisions which had been made. And just perhaps if I reinforce the point which I make in relation to those A, being subsumed, and B, being in no way objectionable. So that's the second strand of my submission. And perhaps if I just pick it up in relation to the transcript of the 13th of January hearing at this point, because I can demonstrate both in relation to that and in relation to the 24th of March hearing that no particular disadvantage was applied to the father. So perhaps if I just do that as quickly as I can. The 13th of January transcript starts at page 82. And the judge is dealing with case management. I'm bound to say that there does seem to be some issues about the quality of the CVP recording, but at page 86 we pick up, can you hear me? Directed to the father, can you hear me? This is line 28.
Right.
And so the judge is making directions for the mother to attend, and then
time is mentioned at
87,
line 18.
Line 18, and then line 28. Tell me how long you think you need. And father responds in important terms, I want to retain the fact-finding hearing. I just interject there that the fact-finding hearing was scheduled for the 23rd of March. I want to retain that, so I need 3 weeks. Judge agrees, ideally 4 weeks. There's an interchange where they talk over. The judge at the top of 88, you can certainly have 3 weeks. I can extend your response to 9 March, because I think that gives the time the parties to give a consolidated schedule by 16 March, which is in plenty of time for the 23rd. So what the judge is saying, I need a comprehensive schedule for everybody to work from. It's got to be in a week before so that everybody's prepared. And so that is the timescale which dictates what should happen. And then in terms of the mother filing her Scott schedule, what date will that be? He says, I'm content that it's the 16th because that allows you 3 weeks to respond. He says, I think realistically the delay in this disclosure has caused difficulty, but I think it's fair to both sides. So I'm not sure there's anything else to decide because everybody else seems to be keen to have the final hearing. Let me hear from Mother's Counsel. And then there's a reference to the issue of privilege. Now, I just sketch in there that there had been a direction for the items to be listed, and I suggest that we produce a list of documents we say are privileged. So I think that's the direction of travel. At the top of page 89, I think there needs to be a list. I think it needs to explain, without revealing, of course, the contents, the reason the privilege is claimed, and I will deal with it on that basis. It cannot be right for me to see the documents and then adjudicate the case. I'll see a list, and I'll take a view on that. And then there's a reference to statements and Scott schedules. I think the balance of this part is not of particular importance, but in terms of father's responses, at page 90, father addresses the judge, when should I expect to receive the disclosures? He says 27th of January, and the father raises the point about 3 months, and then a reference to disclosures. And the judge asks specifically, what would you like me to do about that? I'm struggling to understand whether judgment is fair of the mother having 4 months to prepare and us having 3 weeks. Do you remember I asked you how long you needed? You told me 3 weeks. I need at least 3 weeks. And his response is, if it was 4 weeks, it would be more ideal. And the judge says, I think you can see, but we can't. The judge continues, you'll have more time than 3 weeks, because if you get this disclosure by 27 January, you can start looking at that. And the judge then says...
Then he says if it comes out of the diary, it's not going back till the summer.
Yep. A reference to the penal notice. So if I call it the 3/4 week issue, it's a non-issue. It's the classic trying to fit the hearing into a timetable. But of course, it didn't in fact take place, because the next hearing is the 24th of March. This is the transcript.
Before you leave the transcript, do you have any submissions about whether there's any unfairness to the father arising out of the exchanges you've taken us to?
I would simply submit that it's a fairly standard case management. The judge heard a view and has to adjudicate between a relatively short point as to 3 or 4 weeks. Classically, judges do this all of the time. And when one comes to look at the next hearing to see whether or not there has in fact been any impact of that judgment, any impact of unfairness, one does not see it. This is the judgment which the judge didn't have before him during the course of the hearing, but is the one that was emailed by father to the learned judge. This is the hearing on the 24th of March. It's the one where mother did not attend. Father is represented by Mr. Smith for the purposes.
Yes. You said a judgment. You mean the transcript, I think, actually, Mr. Armstrong.
Transcript of hearing.
On page 94.
Page 94.
Right. Which bits of this do you want us to look at?
And the Mr. Smith, on behalf of the father, at page 96, deals with the discussions that have taken place and the fact that there are 3 days available in June. Because of the illness, because of the illness to the child, it means that we're not able to have a fact find now. Would have to take advantage of 3 days in June. The delay. It is regrettable both parties would agree not to have the fact find, but would want to raise the final hearing. And then the judge raises the point about if there's a transfer of residence in favour of the father.
Yes.
And then there's an issue in relation to the way in which the hearing is going to be conducted. That's dealt with at page 98, line 20. The statement stand as evidence chief. All fairly standard points. Judge at page 99, line 13. So I really want to focus in timings, because what I'm absolutely clear is the time available is generous, but we need to deal with the evidence and submissions in the first 2 days. Multiplicity of allegations, I need the whole day to provide a judgment and hand down, and they have a short case listed, and probably move, give us a clear start and so on. All typical case management. Then there's a reference to the time which each party is going to take. Mr. Smith, on behalf of the father, at line 21, for mother's allegations, if the allegations are going to stay in the substance, roughly what they are, then I think it's going to be about 4 hours. If that's the case, really her witness statement in chief. Mr. Smith, it's a day, and then that's all in relation to timetabling. And then we come to the judge saying at line 8 on page 100, I propose to give judgment. Do you agree with that proposal? Clear template for both. Do you agree with that? Both parties agree allowance to be made for an interpreter. Judge, at line 22, we just need to keep to the time. So we've got a finite amount of time we need to conclude. And judge then goes on to say, I'm still clear. It needs to be attended, there needs to be an but I do not think there should be any further filing of evidence. Mr. Smith, on behalf of the father, can I just raise this? If one looks father's allegations, he represented himself. Would Your Honour permit father to draw up a schedule of this? He's only listed as 5 on his allegations. I think there's 2 broad headings. I think the court's time could be saved if I spend time with the father this afternoon. Therefore, my friend would clearly know what he specifically breaks off. That seems to be a good idea. And then there's a reference to the questions in advance, because there'd been a direction for questions to be written in advance, but that passes away if the parties are going to be represented. We then move to 102 at line 6, where the judge says, father submit questions by 13th of May unless he's legally going to be represented. If he does not need, if he's instructed lawyers, other issues we need to resolve. What was your view of Mr. Smith's offer to tidy up the father's evidence? No objection to that. And Mr. Smith continues at page 102, line 18. I'm so sorry. Father raises he don't believe to be fully addressed and may now have at hand further evidence he'd wish to adduce. I haven't seen that, obviously. I wonder if Your Honour would permit that within this order. Father to be allowed to serve on the other side evidence he'd wish to adduce. If it's opposed, that could be heard first thing on day 1. It's one of the difficulties of litigants in person. They value things that aren't of that value and diminish things that are of that value. I wonder whether Your Honour will be so kind to give him at least an opportunity to gather evidence now he's legally assisted. And that can be done if it can be said. It cannot be agreed. It's simple, straightforward. What do you say about that? No criticism. But if father produces evidence, one has to respond.
So essentially the judge rejects that proposal.
Yes, indeed. But what he's saying, if one turns to page 103, halfway down, starting at line 6, he says, limit to dealing with tidying up exercise, which makes exceed the scope of what you explained to me. And then Mr. Smith at line 15, there's 2 pieces of evidence that wouldn't satisfy Your Honour as being relevant, but he may have other important evidence he doesn't appreciate. He can have 7 days to file an updated statement tidying up matters, perhaps alerting to the parties to additional evidence. And then there's a reference to the schedule. And over the page, if father's line 4, but I think if father seeks to adduce further evidence, it will need to be listed for a hearing before, because there's not going to be time on those days to deal with those arguments. He'll need to make a specific application. Again, if I may respectfully say, sensible case management allows statement tidying up if there's some brand new piece of evidence which is likely to disrupt the timetable for the hearing, then there'd have to be an application so that it doesn't disrupt the hearing taking place. So I simply say father has not been disadvantaged by any of the decisions which were taken on that day. We then move to the issue of the disclosure, where everything is disclosed except one particular document. You pick up that from the judgment at page 112.
Transcript, I think.
Sorry, transcript. Sorry, I'm terribly sorry. And there's a reference to one email, which is, I think when it says 1345, that's page 1345 in the bundle. It's described as, bottom of 112, as a security breach. Your Honour gave the indication that it's to remain redacted. And then he doesn't have it, judge doesn't have it within the index. A reference to, at the top of page 114, line 8, to items which are legally privileged. But the judge says he'll look at that particular document. It's sent to him. It's a short email.
Sorry, where are you now?
Page 114.
114.
114, line 8. This is,
yes.
It's somewhat bitty as to how the, as often is the case with transcripts of case management hearings. The judge is saying items which are legally privileged, and then he's referring to the disputed item, which is an email from the refuge to the solicitors. He's saying it's not privileged, but I'm prepared to look at the document and consider your submissions, but I can't consider it without seeing the document, because he doesn't have it in his bundle. It's then been sent to him. Reference to that, and Judge McPhee, no doubt having seen it, a very short email, I think we can summarise this as the agency or refuge determining that because of safety and security...
Where are you?
Line
29.
Line 29, page 1114.
Right, so this is a question of disclosure, and the judge says it's not relevant to the issues I've got to decide, therefore it needn't be disclosed.
Indeed. And then he goes on to say, in response to Mr. Smith at top of 115, line 2, will it assist in a consistent statement, or whether it will be on a factual basis? If that happens, I will review it, but I see no purpose in this disclosure, and that's brought to a conclusion. So that very short email is the only point where father could even begin to advance a case that he's been disadvantaged. But it is unclear as to what issue in relation to the proceedings that email related, no relevance, no probative value, not proportionate. But the judge keeps an open mind.
It's not a piece of information that could possibly bear upon a recusal application half a year later.
Indeed. And if that document, if that single email had become of crucial importance in the course of the fact-finding hearing, one would have expected counsel for father to have raised it to sought disclosure, and if disappointed in relation to the way in which the judge ruled on it, it would have been the subject of the appeal. So I hope I've dealt with what I would describe as the second thread, that is, that when examined, the case management decisions do not disclose any disadvantage to the father in the conduct of his case. But if I return to the judgment of His Honour Judge McPhee that we were looking at, he deals with the issue of case management. Both parties would be aware of all those decisions which had been taken because they had been present during the course of those hearings, and it forms, if I may say, part of the information which would be available to the neutral observer. The difficulty with Mr. Justice Newton's judgment, if I may respectfully say so, is that he has taken individual points in relation to this, but he doesn't seem to have gone through the transcript of the judgment which was before him on the 13th of January, but seems to have accepted father's complaint as such. And although he had the transcript of the judgment emailed to him, he didn't invite further submissions on it one way or the other. Not clear whether or not he read it. Clearly father was referring to it during the course of his submissions because he makes reference to the transcript. But if he had, the learned judge would have realised that there was in fact no disadvantage. So as we pick up from Mr. Justice Newton's judgment, his judgment, this is at page 249. We'd looked at paragraphs up to 16. He then moves on to paragraph 18, Judge specifically referring to Mr. Justice Arbuthnot and not refocusing himself. Then in 19, that of itself gives some anxiety because it's implicit in what father says, to be in a position to consider once the judgment has given his determination on recusal, when a judge makes a direction and order in respect of adoption but waits for the time when the appeal is passed. That appears to be the view which is expressed by the judge, but we say that it's wrong as a matter of case management and as a matter of principle. The judge is entitled to come to a view about recusal and then to proceed to deal with the case, as I think the later cases show. The judge at paragraph 22 refers to points which are being raised by the father in his document. He rejects the Arbuthnot complaints at that stage, but he was unfair, he was not afforded the right to challenge the substitution, as indeed were other issues. But it's very difficult to see the basis for that, because if one looks at the order that was made by His Honour Judge McPhee on the 9th of September, 399 for 403. He deals with that in paragraph 8, where both parties raised amendments. This is at page 400. Both parties raised amendments to be made to the judgment. The court agreed to review this judgment and recirculate the amended judgment in due course. It's a matter for the judge and not for the parties to argue or seek to cross-examine in relation to the finding of the judge. At 250, Mr. Justice Newton relates a second ground. The evidence was received. Draws support that the mother was able to file evidence outside the scope of the order of District Judge Moses on the October 2021. That's clear reference to the January order. He'd not been given the same latitude. And then there's a reference to the March hearing in the transcript. He says, in addition, because of the presentation of the case, he was told, for example, by the judge, I've seen it, to lodge a separate C2.
Sorry, where are you reading now, Mr.
This is page 250.
I'm sorry, my mistake.
Page 250. And this is paragraph 22, where the judge is, well, Mr. Justice Newton, is effectively...
He's summarising the father's argument.
Yes, indeed. He's summarising the argument. But with respect to the learned judge, he's getting it wrong, because, as we've just seen from the 14th of March order, the judge was giving him a further opportunity to tidy up his evidence. And if there was something new which happened, saying to him that there should be a C2 application.
Yeah.
So, again, although the judge is referring to a transcript which is lodged after the hearing has taken place, it's not a fair summary of what took place. And then a reference to the withheld document, which may or may not be relevant. The judge looked at, decided were not privileged, but nonetheless withheld from father's case. He seems to be determining that in some way that the procedure which the judge adopted on the 24th of March in relation to that single email was unfair to him. The third ground of failure to acknowledge significant risk, that's nothing in that. The fourth is in relation to judicial comments. He relies on what occurred on the hearing the 13th of January, difference approach in relation to latitude. Again, having looked at the transcript of the judgment, which the judge had before him, there is no unfairness to the father.
Is there any identification within the papers that we have of what might be regarded as judicial comments? I mean, when one sees judicial comments, one imagines that one's talking about some unfortunate expression or some way in which a judge misspoke or treated a witness discourteously or showed that he was favouring a particular point of view.
Well,
is that the nature of this complaint?
Well, it's very difficult to see anything that took place on the 13th of January or the 24th of March as being discourteous in any way to the...
We haven't looked at the father's skeleton argument before Mr. Justice Newton. Does he spell anything out there?
I'll just go back to...
It's at 468 or thereabouts.
perhaps if one
And
looks
round 4 is specifically on page 476. Instance 10 we've looked at.
Instance 11 is the dispute resolution hearing. Now, on the 9th of September, we've looked at the order in relation to that, and that order is the order at 399. And the reference is to paragraph 5, which is the reduction of contact, and the only reduction in contact is that the car journeys and hence visits in London would not take place, but that's an interim decision. The judge went on to say he's not predetermined the outcome, which is exactly what he says in the order, but the judge didn't have a transcript of the hearing on the 9th of September before him, so it's difficult with respect for the judge to have made the observation in relation to the hearing which he appears to have relied upon, because he's just relying in effect on the father's say-so.
These 5 points that are made at page 249 to 250 appear to be a mixture of reference to what the father's complaints are to Mr. Justice Newton, and commentary by Mr. Justice Newton to some extent on those matters. If you'd be so good at the bottom of this, he refers to the intertwining issues. Absence of reasoning. He draws support from the remarks, unfortunate remarks, that were made at the end of the 16th of November hearing.
Those
Could you help us as to what?
Those are a reference to the. Forgive me for a moment. To the short direction where the judge said he wanted some assistance. So if you look at page, I think it's 152 or just before that. Sorry, it's 149. This is the hearing that we looked at a moment ago on the 16th of November, where having started to deal with the issue of nasal flu vaccination.
Yes, well, I mean, can we take this quickly? What conceivably are, we've been through this at great length, what conceivably are the unfortunate remarks at the end of that hearing?
I can't identify.
I mean, there's the episode which you passed on where the father interested himself in the qualifications of the mother's solicitor.
The only reference, and it's one which is referred to by the, I think, the father in the course of his submissions. It's the 149
line 10 to 15,
10 to 15,
which you drew our attention to.
Indeed.
You surmised those are the so-called unfortunate remarks.
Well, it could.
I mean,
They're in the father's skeleton argument.
It's the father's skeleton argument, and right. That's it.
Yes, indeed, and he does in fact do make a quotation in relation to that, which he doesn't quite doesn't fully reflect that.
Mr. Armstrong, it's 20 to 1. Miss Renton needs time to reply to you.
I've taken a little bit longer in exposition. Can I speed up, perhaps? Can I finish the issues in relation to this judgment? I hope 5 minutes in relation to that. Then I'm going to just briefly look at some of the cases in relation to that. So I would hope to conclude by 1 o'clock, or perhaps very shortly after that. If that's
Yes,
of course.
Yeah.
Can I then pick it up? The reference that we were looking to is the paragraph 41, which is where the judge is effectively saying that there's some foreshadowing of a predetermination. Intertwining was an issue which he referred to also in paragraph 41. That derives, in fact, from the permission hearing before Mrs. Justice Morgan, where this is 483, where the matter comes before Mrs. Justice Morgan for additional consideration, where it would appear the judge is being given a limited number of documents, and those are enumerated there, 16th and 23rd of November, 16th transcript, and then the judge at page 485 refers to the words interlinked. This is at 485, about 4 lines from the bottom.
Yeah.
And Mr. Justice Newton refers to them as being intertwined.
Yes.
This is in paragraph 41. When one actually looks at the judgment of Mr. Judge McPhee, what he does is he makes very clear on the 16th of November, in the passages we've already referred to, that he's going to do it in stage by stage, deal with recusal first, deal with that. That's exactly what he does do on the 23rd of March. He gives a judgment in relation to that and moves swiftly on to that.
Those are described in paragraph 41 as the remarks made to counsel.
Indeed.
So it does seem as if those may have been the matters that were concerning Miss Justice Newton.
With respect to Mr. Justice Newton and indeed to Mr. Justice Morgan, although they're contemporaneous in the sense that they're dealt with sequentially, there is no interlinking or other way in which they are dealt.
Can I just try and understand? Sorry to interrupt you again, Mr. Armstrong. What do we think Mr. Justice Newton was thinking should have happened here? That the issue of the application was listed before the judge on the flu vaccine issue. In the middle of that, the father makes a without notice application for recusal. Is it suggested that the judge should have adjourned the question of flu vaccine to a different date from the date on which he determined the recusal application? Is that, have I missed the point?
Well, that would seem to be the thrust of what Father is saying.
Three hearings.
Well, indeed. At further expense, of course, this is a child. The application's been made in September. We're in the flu season. If inoculation is going to take place, the earlier it takes place, the better. It's a fairly standard case management decision that has to be made sooner rather than later. And if past proceedings are anything to go by, if one had followed down the route of recusal application, stay, hearing of appeal, and so on, we'd be a long way.
The alternative course would have been to do what the judge said he was going to do, and then if the father had wanted to challenge the recusal application and the flu vaccine application, he could have appealed and sought a stay pending appeal.
But he certainly didn't seek a stay from the learned judge, and one can see that from the final part of the judgment of His Honour Judge McPhee on the 23rd at page one. Sorry, it's page 157, where he, having given his judgment on recusal at line 23, he goes on to deal with the issue of the vaccination. He then goes on to the top at page 159, the judgment is given, and then there's a discussion between the parties, and the judge concludes it. But at no stage does the father say, I want a stay of the vaccination issue. If, as would appear to be the case from his oral submissions, he was neutral or agnostic in relation to that, he certainly didn't appeal or ask for a stay in relation. So he certainly didn't ask for a stay in relation to the nasal vaccination later, and he certainly didn't appeal it. And the only appeal that comes is in relation to the recusal application, where subsequently His Honour Judge McPhee gives a stay because of this.
Do you have paragraph 43 of the judgment there, which is
Sorry, I've just
where the judge ends? page 253, where he summarises why he's denying the appeal. Three things, but in reality two. One, no reasoning. Two, procedural irregularity. And three, he then just says that the test in 40 is satisfied. But, your submissions have been to the effect, as I understand it, that he had no basis at all for the second point. There was no procedural irregularity of any kind. Anything more you want to say on the question of no reasoning? We've looked at paragraphs 3 and 4 of the judgment where there's some reference to case management matters. Any other submission about that?
Well, dare I say, judges at every level dealing with recusal applications often have to deal with them quickly and proceed on with other matters that they have in the list. In my submission, the reasons given by the learned judge are sufficient to set out.
The judge had a week here, didn't he, to deal with the application?
Sorry, I missed that last one.
The judge had a week, didn't he, in which to deal with the application? This is not an extempore judgment given straight after the application.
Well, I suspect that as an experienced judge, he would have been able to consider the main issues and deliver a short judgment, without any difficulty, having thought about the vaccination issues and having thought about the recusal.
That you're in fact presenting is that it's perfectly obvious what the judge would have said about all the matters, because once one's been through them thoroughly, there's absolutely nothing there.
Indeed. Well,
as to all the case management complaints.
Can I?
Well, is it? I mean, what is your submission about it, Mr. Armstrong?
So,
The appeal may turn on it.
The reasons point does feature quite strongly, as I read it, Ms. Renton's argument.
Indeed.
And it featured clearly in the judge's. There it is. It's number one of the judge's reasons. Mr. Justice Newton's reasons.
The short point I make in relation to that is that the reasons are based on the judgment of Mrs. Justice Arbuthnot.
Was the judge right to say that the case management issues were subsumed, as you put it? You say.
Well, I say very, very obviously. Otherwise, if I may put it, that there would be, in effect, two grounds of appeal, one the substantive ground of appeal and some later decision alleging some degree of favouritism or bias in many, many cases, where somebody suggests that there has been a failure or a latitude, if I use the word that Mr. Justice Newton used, given to them. The parties bound to present their appeal on the basis of all of the issues which are apparent at the time.
So, are you saying they were implicitly considered by Mrs. Justice Arbuthnot, or that they should have been raised on appeal and weren't?
Should have been raised on appeal and weren't. We have the only decisions that relate to case management directions. There's only one, which is the paragraph 19 point. So far as his explanation, the cases show very clearly that the judge is not to be cross-examined about allegations of bias. The judge in paragraph 7 acknowledges his own error, and he made it very clear that he was prepared to review his decision and to correct it. Indeed, corrections fall into many categories, and indeed judges do routinely correct matters where there's been wrong or a misperception in relation to it. Indeed, the barrel jurisdiction allows the judge to do that if he so wishes to do it. But the conclusion that he comes to in paragraph 8 is it doesn't impact on the remainder of the findings, and he didn't review any other part having regard to the submissions in it. He acknowledges again the error, and his conclusion is that my
view is the test is whether fair-minded, having considered the facts, real possibility of bias, and that, of course, is the point about a real possibility of bias. Lord, I'm not sure I can take matters much further than that. It's a short judgment which is given. Lord, can I just pick up some legal points in relation to this? The court has a bundle of authorities and no doubt very familiar with many of them already. So perhaps I can just, for these purposes, note the point which is made in Porter and McGill, that it is not the perception of the complainant, it is the objective view of the court that there is a summary of principles which the court may find of assistance within the judgment of Ansara and Lloyds Bank, which the court has at page 300. And the propositions of Mr. Justice Burton are set out, enumerated in paragraph 10. The court has very much in mind that the mere fact that the judge in an earlier case, previous case, is 307, paragraph 6 on that page. The fact that adverse comment on a party or witness have found the evidence to be unreliable would not, without something more, be found a sustainable objection. The Otcreti case is an important one. Otcreti, this is at 315. This is where I think it's Mr. Justice Eder had made adverse findings and then
It to determine the wasted cost order or something like that, wasn't it?
Indeed.
Well, contempt, is it?
He recused himself, and the court considered that the judge should not have recused himself for contempt. If one picks up from the head note,
Yeah.
the paragraphs H8, H9 and H10, court would usually support. The judge had been wrong to find the allegations of actual biases to his criticism, and no more than suggestion should have found the facts were differently at trial. That has resonance with this particular case. And then I think there is an important reference to long-running cases at page 322, paragraph 18, a reference to the importance of case management. The hypothetical observer is not one who makes this judgment after a brief visit to court, but one who is familiar with the detailed history of the proceedings and the way in which cases of this kind are tried. That's the indented paragraph.
Lord Justice Chadwick, isn't it?
Yes, indeed. And
No, it's not Lord Justice Chadwick. I beg his pardon.
sorry, it's
Sir Thomas,
the
Lord
Master of the Rolls.
Yes, my mistake.
And then he continued with a salutary passage. In cases such as this, in which interlocutory applications proliferate, it may well be that one side fares more successfully, perhaps much more successfully than the other. Number of possible explanations. Most obvious being a successful party has shown greater judgment, determination, knowledge of the rules. Mr. Monroe accepted that no inference of apparent bias can be drawn from the fact that most or all interlocutory applications had been decided against. Dr. Hashim also disclaimed any attack on the interlocutory
decision, and then a reference to Locker Bail in 19 as to the top of page 323, the court rejecting evidence in such outspoken terms as throw doubt on his ability to approach the person's evidence with an open mind on a later occasion or on any question at issue, express views in the course of the hearing in such extreme or unbalanced terms. We say that does not arise in the present case. And in my submission, the case indicates the importance of the trial judge for all the reasons which are obvious in relation to case management, remaining to hear the case, of course, in paragraph 27, the reference to the Triodos Bank and the what may be described as the easy option, which a judge can take but shouldn't be taken in those cases. There is just one other case that I wanted to illustrate the point. Yes, it's the Watts case, which the court has at page 172. If I pick it up from, is a dispute over an estate, paragraph 3 on page 173. At the commencement of the trial, an issue arose as to whether the judge should recuse herself on grounds of appearance of bias on the footing in the course of her practice. She was engaged in long-running litigation in which she was leading the barrister appearing as counsel for the sister, Mr. Jordan Holland. So that's the background to it. And then discussion. One can see at page 176, paragraph 17, on the appeal, Mr. McLernan criticised the judge on 3 grounds: for the paucity of the information provided about her involvement with Mr. Holland, for announcing her ruling at the commencement of the hearing but only giving reasons at the end of it, and for the decision not to recuse herself.
Yeah.
And then
Let's start with paragraphs 26 and 27.
Indeed, the judge was not at fault in proceeding on with the hearing, and indeed in most cases where there's a reference, where there's an application for recusal on the grounds of bias, it would be appropriate for the judge to consider it either at length or to consider the point in principle, even if the reasons come later, and to continue with the case unless there's cogent reasons.
So this goes to the intertwining point.
Well, indeed. With respect to, as I said to Mrs. Justice Morgan and to the learned judge, I failed to see that there was intertwining to any degree which would in any way be decision A impacted on decision B or in the process by which they were determined. So with the view to trying to keep the time, I've truncated, if I may put it, my submissions in relation to legal principles, because I think those principles are well understood. But we simply say that Judge McPhee was entirely right, and that the appeal on the appeal, Mr. Justice Newton did not apply the appropriate forensic approach in dissecting out whatever it was that the father was saying about the criticism of the judge, and, to use an analogy, to run the hair to ground to see whether there was substance in it or not. The approach which was adopted by the learned judge on appeal took a great deal of what the father said as being correct without that examination. And in my submission, the failure of that approach flaws the judgment on appeal. The one matter that we haven't looked at is, of course, the judgment, the transcript of the hearing on the 9th of September. I have been cautious in relation to that, simply because that transcript
was not before the Mr. Justice Newton at the hearing. So any observations he makes as to fairness or unfairness in relation to that are wholly unsupported by reference to any transcript or any objective analysis of it. And it will be seen that there was a CAFCAS report in favour of reducing contact. So it is not an unprincipled decision which has been taken, but one which very much had the welfare of the child at its centre, and to be looked at again at the next hearing when the judge dealt with a whole raft of issues. If need be, I can deal with it and demonstrate to the court that there was no unfairness in that judgment, but I do not do so at this stage, simply because it wasn't before the learned judge. All that he had was the order that was made, and to extrapolate from a decision in relation to the contact and the welfare that there was some degree of unfairness, as I mentioned it in my submissions, in his note as referred to by the judge in the course of his submissions, the father makes reference to the 8th of June. There was no change in the arrangements on the 8th of June. The only change was in September. So I think there was an error as to the date. Lords, unless there's anything else at this stage, and a minute over time, but Lord, I've done my best to finish.
No, thank you.
Thank you very much, Mr. Armstrong.
Court rise.
2 o'clock.
Thank you very much. Are you both happy with it?